our group decided to do our presentation on workplace discrimination. This video will help its audience to know what discrimination is, how to identify it, and how to stop it from happening within the workplace. The purpose for this training is to help reduce occurrences of discrimination and harassment from within the workplace. This will also help employers to reduce liability claims or employment-based lawsuits. As a group, we decided to choose our topic on discrimination in the workplace. We felt that it is an important issue in today's society. After serious contemplation and analysis, we decided that it was an issue that many employees experience but may be unsure of how to deal with it. We determined that the best approach would be to design a training process. Discrimination has been around for hundreds of years, and in the last century, job openings were based on perceptions that eliminated people based on their age, gender, race, religion, and nationality. Since that time, freedom has grown, and the affirmative action was enacted with the Civil Rights Act of 1964, which helped to eliminate self-identified qualities that prevented people from applying for certain jobs. Soon after the Civil Rights Act of 1964 was enacted, it created a domino effect, preventing future discrimination in the workplace, like age discrimination for the Employment Act, protecting people who are 40 or older, and the American with Disabilities Act, making it illegal to discriminate against a person with a disability. There are two theories of discrimination. There are disparate treatment and disparate impact. Disparate treatment is when an employee is treated worse by an employer because of his or her status as a member of a protected class or category. Disparate impact is a type of discrimination based on the effect of an employment policy, rule, or practice rather than the intent behind it. The anti-discrimination laws make it illegal for a seemingly neutral policy, rule, or practice to have a disproportionate adverse effect on members of a protected class. For example, a strength requirement might screen out disproportionate numbers of female applicants for a job, or requiring all applicants to receive a certain score on a standardized test to be eligible for a promotion could adversely affect candidates of color. If you're being discriminated, you will need evidence to prove if it was intentional or not. There are two types of evidence that can be used to prove discrimination: direct and circumstantial. Direct evidence's discrimination includes statements by managers or supervisors that directly relate to the adverse actions taken against a protected class status. Circumstantial evidence, also known as indirect evidence, proves the existence of a particular fact without any inference needed. Circumstantial evidence pertains to a series of facts rather than one particular fact to be proved. In almost every case, an employee must rely on circumstantial evidence to create a presumption of discrimination. To prove the discrimination in the workplace, an employee must be able to answer yes to the following 4 questions. Are you a member of the protected group? Were you qualified for the position? Did the employer take adverse action against you? Were you replaced by someone not in your protected group? If you answer yes to the 4 questions above, you may be able to establish a presumption that your protected class status caused the adverse employment action. But to be fair, one single piece of evidence won't be enough to prove discrimination. Once you have established a presumption of discrimination, consider the reason that your company gave if, for example, you were terminated. In court, an employer has the opportunity to offer a legitimate, non-discriminatory reason for its conduct. The law only requires for the employer to articulate or state a reason for its conduct. It does not have to prove that it is the true reason. A company can almost always come up with some reason for the action that it took. Once the employer articulates this reason, your presumption of discrimination is gone, and you will have to offer additional evidence. If the employer cannot offer a legitimate reason, in this case, for your termination, the presumption remains and you have proven a case of discrimination. However, Don't count on this happening. You may think, my employer can never come up with a good reason for firing me. Recall, however, that your employer doesn't need a good reason, just any reason besides your protected status. The vast majority of employers can do this. Unlawful employment discrimination is hard to prove. You may be able to prove that the employer's stated reason is just a cover-up or pretext for discrimination if you can prove any of the following: that the stated reason is factually untrue, the stated reason is insufficient to have actually motivated your discharge, the stated reason is so riddled with errors that your employer could not have legitimately relied upon it, your protected status is more likely to have motivated your employer than the stated reason, is it powerfully direct or circumstantial evidence of discrimination. In order to successfully challenge your employer's denial, the law requires you to prove that your employer's stated reason is false and that your protected status played a role in your termination. What can I do and how do I stop it from happening? Inform the harasser that his or her actions are offensive and inappropriate. Sometimes letting the harasser know that their words or actions are making others feel uncomfortable could end it altogether. Some harassers just don't know they're engaging in such behavior, but it's no excuse for either party to let it continue. If you're not comfortable approaching the harasser, just write a short letter to let him or her know that you would like their behavior to stop. If the harassment persists, file a complaint to your supervisor or HR. If you don't get the proper response from management, continue escalating the complaint up the chain of command. If all else fails, hire a lawyer or contact the EEOC to evaluate your claim. Write everything down and gather all the evidence to prove your accusations. Make sure you follow company procedure. Inform your company of the behavior and document everything. If you don't follow company procedure and give them a chance to stop the harassment, you will likely lose in court. In cases like this, it would be wise to document everything before proceeding. The process for filing a discrimination charge is 180 days from the time of the alleged practice. Once the files have been submitted, notices are sent out to the employer stating that they are being charged with discrimination. Both parties, plaintiff and defendant, then must have solid evidence and be prepared to support their beliefs and actions. For remedies, whenever discrimination is found, the goal of the law is to put the victim of discrimination in the same position, or nearly the same, that he or she would have been if the discrimination had never occurred. Remedies can include, but are not limited to, back pay, reinstatement, lost benefits, emotional distress damages, and even punitive damages. In conclusion, the overall purpose for this training is to create a safe and secure environment for the workplace that will allow employees to be more productive and motivated. Through this process, we were able to see the importance of training by using ADDIE to help us to understand how training and development can be implemented for any organization.